I will remain the main objectives of both the EU institutions and the United Nations. It is first securing better access to justice. We have spoken a lot about it. And therefore to provide a cost-effective and quick extrajudicial resolution of disputes in both civil and commercial matters. We have also a little bit spoken about that with Mrs. Greta Scottier, and Jan, you have just said it is good itself. And the last aspect is to promote alternative dispute resolution in cross-border disputes, also in internal and international processes. I would like to remember the following rules very shortly. You have the 3 European main rules, the directive of 2008, that is the fundamental directive for mediation, directive in 2013 for consumers, and the regulation of 2013 on online dispute resolution to settle disputes connecting domestic and cross-border purchases. And Professor Bachmeier spoke a little bit about the problematic of online conflict resolution. And then the more international rules, you have the United Nations Commission on International Trade Law, the UNICITRAL, and you have 2 types of international rules, the UNICITRAL models for arbitration, mediation, and conciliation, and the United Nations conventions, and you have the Singapore Convention. We have spoken about it, Professor Kandashvili. And then last but not least, very important, the 1968 New York Convention on the recognition and enforcement of arbitral awards. Enforcement is very important. But, and also the laws in the different countries, of course. But we have to see that despite all those regulations, all those regulatory standards, the situation is very poor. The European Commission made a study in 2014, and the conclusion was that for mediation, for instance, less than 1% of the trials go through mediation. And so we are proud now to reflect on the regulations and to bring our reflections and to hope that we can make the situation better in a long term. The questions that we will see is, what is a regulation? How to improve implementation? That's the main problem. You can make the best regulation on the world. If the implementation does not follow, it has no sense. What is the impact? What is the increase? What could be the increase of alternative dispute resolution? The degree of regulation should be adapted, but extensive or limited? Is it an idea to make the mediation itself mandatory? We have also spoken about that, but if we want to improve, do we have to rediscuss the solutions? How to ensure enforceability? So having listened to the truth from the European side, we will with great interest also listen to the AIJA experience and to the Australian experience. So all the speakers will have 5 minutes, which is not long, of course, and I will immediately give the floor to Anna Wyrzykowska. She is president of the International Association of Young Lawyers, AIJA. So it's important to start with the young lawyers, of course. She's partner in a law firm in Poland, Wyrzykowski Kieryński Bar. Excuse me for the pronunciation of the name. His practice is focused on real estate, merger and acquisition, and corporate law. She is also lecturer on corporate and real estate law at the Warsaw Bar Association, author of publications. She has studied in Warsaw, Poitiers, and Florida in the United States. So she is the perfect citizen, young citizen of the world. And I give you the word, Anna. Thank you.
Thank you so much, Olivier. And your pronunciation is really not that bad. Indeed, I'm a lawyer based in Warsaw, Poland, but I'm here in my capacity of the president of AIJA, International Association of Young Lawyers, therefore lawyers under the age of 45. And although I appreciate your very insightful presentations and information on how the world of alternative dispute resolution look like in different countries, and what is the perspective of lawyers actually practicing the ADR or litigation, I would like to give you a completely different perspective from the eyes of young lawyers. I would like to share my presentation. I'm not sure if I should share it, or Rafał, will you be sharing it? I just want to...
If you could share it by yourself, it would be the best way.
I'm not sure if you see it.
Yes, perfect.
I will just close the window of Zoom, because you will probably see the black square.
We see a young lawyer.
Yes. I would like to, well, I have already told you a little bit about AIJA. We are an association actually having 60 birthday next year, and I have the privilege to represent AIJA as the president. We have 21 scientific commissions, and among them there is a litigation commission and international arbitration commission. This chart also briefly shows how we support diversity and inclusion in our association, which we are really proud of. But I want to tell you, given the topic of today's webinar, and I'm very grateful for this invitation, what we have discussed also about alternative dispute resolution during our annual Congress in Zurich. It took place in August this year. It was fully devoted to innovation. And we've been discussing, among others, about innovative claims and proceedings. And the target was to determine whether innovation is positive or negative in dispute resolution, including, of course, ADR. We had an incredible intervention of our keynote speaker, the judge of the Supreme Court of Canada, Mahmoud Jamal, and he delivered very insightful thoughts to the discussion, because he briefly summarized how, lawyers practicing dispute resolution at courts, but also alternative dispute resolution, how they were approaching technology and how the technology changed the way the dispute resolution is looking like. So in the past, technology was already entering, of course, the world of dispute resolution, but not the courtroom and court works. But shifting the dispute resolution only or to online only is also not a good thing, as it was mentioned by the judge, because we can't really control the process of arguing and consideration made by the judge, arbitrator, or mediator. In dispute resolution, work with paper was always valued, and in-person or oral argument was not as valuable as paper motions. And we observe now, while discussing about innovation, that those new standards for electronic documents reversed the balance between paper and electronic materials. And these days, the electronic documents are getting more and more accepted. But does this mean that the courtroom should also be digital and the whole dispute resolution process should be digital? That was something that we discussed in Zurich this year.
You have
Why?
1 minute.
Why? Because the Zoom fatigue makes the parties getting to the point faster, so faster lawyers are better. This limits the possibilities for less efficient speakers. It is inclusive for disabled or those who are located far from location where the dispute is settled, which proves, on the other hand, accessibility of justice. It takes less time and therefore it is cost efficient, which again proves accessibility to justice. And is court a service or dispute resolution a service or a place that we are actually going to with certain targets? And in lockdown, we largely learned, because of the technology, that it is actually a service. As a side note, the judge mentioned that in Canada, actually, the first online tribunal was created. But this is, of course, something that enlarges the access to justice and access of regular courts. But what does it mean? And that's the question that I want to pose you, specialist in ADR, how that potentially might impact ADR. Because for now, we were always arguing that alternative dispute resolutions are quicker dispute resolution models, are better because they're more accessible sometimes they're more expensive than regular court cases.
Thank you, Anna.
But this,
thank you for
will
your
this
very
change?
interesting view. But I have the difficult task to limit, so I give you a small time to end your very exciting speech.
Oh, actually, I wanted to end up with this question. You will see my presentation. It will be shared by the organizers. You will see the opponents and you will see the supporters, how technology impacts the dispute resolution world. But actually, the question is to you, the ADR practitioners, how you think the technology will affect the ADR world, but not just ADR world, how the changes within the regular dispute resolution at courts might potentially be a threat to ADR if the accessibility to justice is bigger due to the technology. So that's something that we see as a perspective of young lawyers. Thank you very much.
Thank you very much, Anna. Very, very interesting. I will give the floor now to Mr. Panagiotis Perakis. Mr. Panagiotis Perakis is expert in corporate law, he has an extensive experience in alternative dispute resolution. He has served as independent legal expert for the European Commission for Information and Telecommunication Matters. He's member of the executive board of the Athens Bar. He was appointed, and that is very interesting for us, as chairman of Access to Justice Committee for the Council of Bars of Law Societies of Europe, the CCBE, and he's now the vice president of the CCBE. And despite this very big diary that he has accepted to come and to share us his views about the CCBE on regulatory developments in Europe. Mr. Perakis, you have the floor.
Thank you. Thank you very much. I would like to thank organizers for inviting the CCBE to participate in this conference and the possibility to discuss a very important topic on access to justice, especially now when we are still recovering from numerous lockdowns and their influence on access to justice for citizens. I'll try to present the main elements which, according to our views, any regulation about ADR should take into account. Justice is a fundamental value of utmost importance in the life of every citizen. But justice does not always originate from the court. Therefore, the legal profession should display advanced reflection and in-depth knowledge of all dispute resolution processes available across a broad spectrum. ADR could be viewed as one of the remedies as a pillar of the justice system, which can support the judicial system and improve the overall access to justice. We have to admit that sometimes, like, for example, in some family cases, a dispute does not require a decision about who is right or wrong from a legal point of view, but a cooperative process where parties can come to a solution that is beneficial to all parties. ADR could better serve to that direction than the traditional justice system. The CCBE supports the use of ADR processes as a voluntary alternative to judicial proceedings. In 2018, the Commission for the Efficiency of Justice, CCBE, the Council of Europe, has adopted the Mediation Development Toolkit, a guide to mediation for lawyers, which was elaborated jointly with the CCBE. This was done also to raise the awareness among lawyers about ADR processes. In this guide, next to the detailed explanation and analysis on the role of lawyer within the mediation, the role of bars and law societies in helping to create a mediation-friendly environment was described. In my personal view, one of the most important aspects here is the need to ensure proper training for lawyers. Therefore, in 2019, the CCBE, jointly with the CCBE, again, has developed a special training program for lawyers to assist clients in mediation. Taking into account lawyers' duty to act in the best interest of the client, we believe that lawyers must always review all options when it comes to advising their clients on the choice of the most appropriate dispute resolution process. Lawyers' approach to dispute resolution must therefore be conceptually neutral. And this is a very important issue. Once an ADR process is chosen, lawyers, of course, still assist their clients throughout the process. And this is also a key issue for us. The support lawyers can offer throughout ADR processes can be enormously beneficial because it ensures that both parties have quality, independent legal advice, are confident to enter into an informed dialogue, and helps to redress any power imbalance between parties. It is important to recognize that alongside many significant benefits, ADR processes also bring their own set of risks and challenges, most significantly in relation to the impartiality, transparency, effectiveness, fairness, and lawfulness of the dispute resolution process. Any regulatory framework should primarily focus on those risks. Contrary to what its voluntary nature might suggest, an ADR process may be used in a way that does not necessarily align well with the rights of the individual or interests of justice. Strong safeguards are therefore necessary to prevent undue practices, as in traditional justice system, such safeguards and guarantees must be ensured. I would like to underline the need of transparency, mainly for achieving the citizens' trust, which is the most important. Finally, there is a strong need to ensure the quality of ADR schemes. At the moment, there is an overall lack of common minimum standards that ADR service providers will have to comply with, including to ensure that their procedures are fair and impartial. We lawyers have a responsibility. That is to ensure access to justice, to make sure that the values underpinning legal procedures are not undermined through the use of alternative mechanisms. We share the common goal to safeguard the proper delivery of justice, to keep justice fair and human-centric, even if processes are taking place out of court or even to a large extent digitalized. The guiding principle when implementing ADR schemes should be the needs of citizens to resolve their disputes in a fair and proper way. Therefore, to conclude, regarding any regulatory development, for us, the key issues are the following. The right of the parties to be informed about the existing ADR possibilities for their case. Our clients should be made aware of the opportunities offered by ADR processes. The role and the presence of lawyers in the ADR processes. The impartiality, transparency, effectiveness, fairness, and quality of any ADR procedure, and the effectiveness of the outcome, recognized same as a judicial decision. I would like to congratulate and thank you for promoting cooperation of lawyers from Eastern Europe, Caucasus, Central Asia, as well as from Central and Western Europe, with the aim to develop knowledge, exchange of experience, and strengthen networking between lawyers. I'm glad to be present today, even if it is via online connection, and I would like to say happy birthday to you because I know that it is your 35th anniversary. Thank you very much and be well.
Thank you, Panagiotis. It was very interesting, and thank you also for all you have to do with the CCBE for the profession. I will now give the floor to the second time to Mr. Remigijus Jokubauskas. I will not present him a second time because he had already spoken today, but I think that he will also speak about the European Commission for Efficiency of Justice, like you have done it. Mr. Jokubauskas, I'll give you the floor with pleasure.
Thank you. Thank you so much. Indeed, it's a great honor and privilege, I would say, to give two presentations in one international conference. So thank you very much for allowing me to do so. So actually with this presentation, and me share my screen again with you, I would like to present the role of the Council of Europe in development of the alternative dispute resolution mechanisms. And I would like to describe the main documents prepared by the Council of Europe in this regard, and what is the direction of the Council of Europe in development of ADR. So first of all, I should mention that ADR has been on the agenda of the Council of Europe for at least a few decades. And the Council of Europe and the European Commission for Efficiency of Justice have prepared a number of soft law documents in this area. And of course, there is no binding legal sources in this area, but these soft law documents definitely reflect the development, the general global development of the ADR mechanisms and the national practices of the members of the European Convention on Human Rights. Also, I think it should be noted how the Council of Europe understands the mediation, and in one of the documents, in the recommendation on mediation civil matters, the Council of Europe has defined mediation as a dispute resolution process when the parties negotiate over the dispute with the assistance of a mediator. So it seems that a kind of common general definition of mediation is used by the Council of Europe. Now, turning to what specific documents have been prepared by the Council of Europe in this area, there are 4 recommendations prepared by the Council of Europe. The first recommendation was prepared and issued in 1998. It was the recommendation on family mediation. After that, we have recommendations on mediation in criminal matters, mediation in litigation between administrative authorities and private parties, and mediation in civil matters. Now, let me briefly address some of these recommendations and what are the main highlights of these documents. So the first recommendation prepared by the Council of Europe, the recommendation on family mediation, includes one very important provision, which I think reflects the general approach of the Council of Europe in ADR mechanisms, is that ADR in general is not compulsory, meaning is that the parties should decide to use mediation instead of litigation. So parties should not be compelled, should not be obliged to use mediation if they do not want to do so. Also, this first document of the Council of Europe establishes the main principles of mediation, like impartiality, neutrality of the mediator, the importance of protection of interests of a child, and other important principles in mediation proceedings. Also, it emphasizes facilitation of the approved mediation agreements and regulates the relationships between mediation and court proceedings. Another relevant recommendation prepared by the Council of Europe is recommendation civil matters. It also includes definition of mediation. It establishes a number of provisions aiming to facilitate mediation in civil matters, and it basically regulates the whole mechanism of mediation from the beginning till the reaching of the agreement in mediation. Another institution which is also very relevant regarding development of the ADR in Europe is the European Commission of Efficiency of Justice, which I have already presented, and its tasks can be divided into two groups. The first area of this institution was from 2006 and 2007, which included the studies of the recommendations prepared by the Council of Europe. So basically, this commission analyzed the situation in the member states, how these recommendations were used, and what are advantages and possible shortcomings of these recommendations. So 3 studies were prepared. And the second period of working of this Commission was from 2017 to 2019, in which it provided certain assessments, further analyses of the applications of the recommendations of the Council of Europe by the member states. So in 2007, 3 guidelines were prepared by this institution, and these guidelines, as I said, basically reflect the practice of the application of the recommendations prepared by the Council of Europe. So the first guidelines was on implementation of the recommendation on criminal matters. The second one was analysis of application of the recommendation in family and mediation disputes. And the third guideline concerned the application of the recommendation on alternative dispute resolution between administrative authorities and private parties. The latest document prepared by the Council of Europe in this regard is the Mediation Development Toolkit, in which there are a number of different documents included, basically reflect the common development of the mediation in the member states of the European Convention on Human Rights. It's a very practical document, which includes a lot of practical solutions regarding how mediation should be organized, what are the requirements for the mediators, and so on. Also regarding ADR, I would like to mention the document which has been already presented by Ms. Lorena in this meeting, and it's the guidelines of the Council of Europe in on online dispute resolution. And definitely the ADR falls under the scope of this document. It's indeed a very practical one. I also strongly encourage to read this document, and also the explanatory memorandum, which explains in detail how these guidelines should be applicable. And finally, let's just make some conclusions regarding the work of the Council of Europe in development of the ADR. So from what I have shown, I think it's quite clear that the Council of Europe works quite actively in the area of ADR in the last few decades. ADR is regarded as a very relevant dispute resolution mechanism, but it does not replace the court proceedings, as I have already emphasized. It's emphasized that mediation should be only voluntary, so the parties should not be obliged to use mediation. And the Council of Europe has issued a number of soft law documents, though these documents are not binding ones, but to my mind, they clearly reflect the common goals and development of the ADR generally, and these documents have been used as an inspiration for a number of laws on mediation and alternative dispute resolution by the member states of the European Convention on Human Rights. So that was it for my presentation. I think I'm just on time, and perfect. I would be more than happy to answer your questions if you have them.
Perfect. Thank you so much. It was very interesting to see how numerous the tools are for us to develop our skills in mediation and ADR in general. Now we will we will go to Asia, and I welcome Mr. Shyam Divan. Mr. Shyam Divan is a senior advocate, practices before the Supreme Court of India. His main practice is over constitutional law and civil litigation, including arbitration law. Mr. Divan received in 2021 the International Privacy Champion Award for Electronic Privacy Information Center, and he has a major role in privacy protection cases before the Supreme Court of Asia. So he has co-author of numerous books. He served on the LawAsia since 2015 and is vice president of LawAsia until this year. He's vice president of the Bar Association of India. So I think he's the right person to give us the view of India and of Asia, perhaps, about the ADR. Mr. Divan, I give you the floor with great pleasure.
Thank you very much, Olivier. Thank you very much for this opportunity. Greetings on behalf of President Chung-Wan Choi of LawAsia, and on my own behalf, birthday greetings to the European Association of Lawyers on turning 35. I noticed that LawAsia is a little over 50, but we'll hide our age for the present. It's an association essentially of lawyers from the region, the Asia Pacific region, jurists, judges, etc. Our focus is on rule of law, human rights, and of course on aspects of commercial law, such as alternate dispute resolution. I don't wish to overwhelm you with figures, but here are a few numbers which I find I was overwhelmed with when I checked up on the Supreme Court of India website, and this is as of 18th of July 2021. What are the number of pending cases in India's judicial system? 39 million. How many cases do we have? That's at the trial court level. How many cases do we have at the high court level? 5.85 million. How many cases do we have at the Supreme Court of India level? It's 69,000 and counting. So you can quite imagine that with this kind of a workload, you have a huge incentive to have dispute resolution mechanisms and machineries outside of courts. And there's been an extraordinary thrust, therefore, backed by parliamentary legislation, to move cases out. And the most successful has been arbitration. We've got, for commercial dispute resolution, really, the only manner in which you can get a commercial dispute adjudicated within a reasonable period of time in the India context is through the arbitration machinery. The court machinery just will not deliver. And so the most recent developments in India are that we're moving away from ad hoc arbitration towards institutional arbitration. So we have now an arbitration centers attached to, it's a bit ironic that the centers are attached to our high courts, but that's true in Delhi, in Bombay as well, or Mumbai. We have an arbitration center which provides an institutional framework both for international as well as domestic arbitrations. We also, in terms of regulations, as far as qualifications of arbitrators are concerned, per se, there is no qualification, but there are a large number of institutes which are coming up, which are training arbitrators. And of course, as I mentioned, since the drive is towards having institutional arbitration, there's a tendency to get empaneled with these particular arbitrators. I took heart from the suggestion which was made about young lawyers, and I'm happy to report that at least one of our high courts, the Bombay High Court, goes out of its way and appoints as arbitrators young lawyers who have both the commercial capacity, but also the inclination to create a reputation for themselves by earning their spurs in this field, rather than rest on laurels in terms of their old arbitration records. So that's a healthy and an important development. The court since 2015 and backed by the legislature has moved to, because India was quite a notorious jurisdiction with a lot of interference by judicial fora into arbitral awards. That's now moved back and in retreat. That's a point of information. There's non-interference now at the judicial level, which is very healthy. There's also a time frame which has now been provided by mandate and by statute of 18 months. It's directory, it's not compulsory, but if you have an arbitration which lingers beyond 18 months, you have to go to the court to go and secure an extension of time. So that's an important development as well. The most recent development, which actually surprised me, was the Indian Supreme Court has now gone so far as to say that because of party autonomy, parties can even choose an arbitration forum. Two Indian parties can choose an arbitration, the seat of arbitration outside India, and therefore enforce that award as an international award. So this is, I think this is the top court in the country. I'm not very sure this will sustain, but I thought I should share this with you because it's an interesting development. I wonder whether the European experience is also similar, where two domestic parties can actually opt out of your own jurisdiction and come into the Indian enforcement machinery through an international award rather than an award which is domestic. On mediation, I'll say two things. Because of this huge pendency of cases, we have institutional mediation mechanisms attached to all our high courts. India is a federation. We have high courts for each of the states, and therefore there are trained mediators at every level. There is a great degree of pressure when it is essentially family or matrimonial disputes or family disputes, and also commercial disputes, which are oftentimes in terms of enterprises between members of family. So that's another area where the court will really push you towards going into mediation. Finally, we have a new law in 2019 in India, where if you are filing a commercial case, but there is no need for urgent relief in the commercial case, we have a special statutory provision for pre-institution, that's pre-institution of the suit, mediation and settlement machinery. So the court tries and says, look, if there's nothing urgent over here, please try and sort it out through mediation rather than burden the already overburdened court system. So those are some of my insights. I hope I'm within time. Thank you very much for this opportunity. It's been a pleasure.
Thank you so much, Shyam. It was very interesting, and I think we have a lot of ideas to take from your speech. And thank you also because you were in the 5 minutes. Now I will hand over to Mary Walker. We go to Australia. And I will say we go to an Australian angel because I have read 2 or 3 times the bio of Mary, and I have seen that she has made thousands of mediation and arbitration. And so I have looked a second time, and it was indeed thousands. And in Belgium, the most important mediators are very happy if they have 300, 350 or 400 cases. But so I was very surprised because Mary has more than 5,000 matters. So I am very interested to welcome Mary. She's also forefront of the ADR in Australia for the last 30 years. She is chair and co-chair of numerous associations. I have seen 9 associations, but I have perhaps missed 1 or 2, like International Bar Association, Mediation Committee, chair of the Law Council of Australia, ICC Commission on Arbitration, and ADR. Mary is among other awards of Mediator of the Year in 2016, 2017, and 2018, and International Mediator of the Year in 2018 and 2019. And she was this year in 2021 awarded a Medal of the Order of Australia for service to the law by the Australian government. So you have understood that I am very glad to give her the floor, and that we are all very interested in what she will share us. Mary, you have the floor.
Thank you, Olivia. Good evening from Sydney, Australia, and congratulations on your 35 years. It is an honour to join you. My topic this evening is ADR regulation, but I'll also try to provide some highlights from Australia. When I first considered this topic, I raised the following concepts and questions. What is regulation? An overarching concept of oversight of performance and activities. How is it applied to ADR practitioners? Is it targeted to the performance of an ADR practitioner, or the quality of the ADR activity or service, or something else? Is an ADR practitioner subject to complaints processes or disciplinary processes? If so, should sanctions apply? What should they be? Removal from panels or something in addition? Is this exemplified in arbitration or mediation agreements or standards applied? Or is this a matter of market knowledge? For example, either an acceptance of competent practitioners or rejection of practitioners who provide inadequate services by the market. Some laws define or prescribe the duties of ADR practitioners, and are they effective? Do they achieve compliance and quality assurance goals? Are lawyers who act as ADR practitioners subject to more regulation? Some guidelines and standards are adopted by referring agencies rather than by the parties. How effective are these processes? Are there usual minimum standards or principles which should apply to ADR practice and procedure? Is this a one-size-fits-all process or something else? Is this relevant to both court-annexed ADR and private ADR? How is this translated into cross-border dispute resolution, noting different legal regimes and cultural paradigms? I will consider two aspects of this topic in the short time we have this evening. What is regulation and guidelines and standards? I will accept for our discussion that regulations refer to the directives or statutes enforced by law in a particular country. On the other hand, rules can be prescribed to regulate activities and behaviours, such as guidelines or instructions for doing something correctly. These are the principles that govern the conduct or behaviour of a person or an organisation. So what is the goal of regulation? Is it creating normative behaviour in a particular context? Is it to create uniformity of service provision or something else? Is it couched in the goal of improving the quality of ADR services? We grappled with many of these concepts in Australia when we were developing the original guidelines for mediators and ADR practitioners. We as lawyers often seek detail, and we're trained to be rigorous and often overregulate. As ADR practitioners, on the other hand, we know the value of flexibility, and in the 21st century, the need for bespoke and adaptable ADR design and processes to meet the challenges we will face. For example, we are likely to face more complex and polycentric disputes in the next period of time. Everything from value disputes, environmental disputes, multifaceted disputes in all areas that we might engage. A reason for the success and uptake of ADR, particularly mediation in modern times, is the flexibility and adaptability of these processes. If we highly regulate the conduct of ADR practitioners and ADR processes, we also reduce the flexibility of ADR processes themselves. I suggest it is a balance. And what we focused on when we first started to look at this area were the crucial aspects of each of the ADR processes, and walked away from being really prescriptive about what people should or should not do. These will be matters for all of you to consider over time. But I needed to raise, I think, this idea of balance. So guidelines and standards. In Australia, there are differences in court-annexed ADR referrals compared to private ADR. Australia is a federation, like India. It now has what are termed multi-door courts in the form envisaged by Professor Frank Sander of Harvard University at the Brown Conference in 1976. Our Western Australian Supreme Court, which is really, I suppose, the exemplar of a multi-door courthouse, has less than 2% of matters that are finalised by trial. The remainder are dealt with different ADR processes and a focus on triage by court officers, whether they be the registrars or judges with a docket system. Our Land and Environment Court is also a multi-door courthouse, and there are many practice notes and procedures now dealing with everything from hybrid processes and also online dispute resolution. New rules have been brought into existence in September 2021 for our Family Law Court, which is a federal jurisdiction, and there is a move to have family arbitrations as well as an increased amount of pre-litigation ADR. Some laws define or prescribe the duties of ADR practitioners and lawyers who act as ADR in the ADR capacity. But I wanted to highlight two things to you. First, our ADR practitioners are now, if they are lawyers, have ADR within the definition of their work, whether as barristers or solicitors. And the definition of court in many of our jurisdictions now includes arbitration, mediation, and other ADR processes. The obligations which attach to being an officer of the court also attach to ADR processes for legal practitioners. So we've moved into a slightly different paradigm to, I think, what I've heard in other jurisdictions. An ADR practitioner also, if they receive a referral from the court, have the same protection and immunity as a judicial officer. So what are we doing here in Australia? We have mediation, mostly as a compulsory referral from courts and tribunals. We also have a great deal of pre-litigation mediation. And if a matter is initiated in the court, it can be stayed if there are requirements for pre-litigation mediation until that mediation has been completed.
Can I give you 1 minute to finish?
Thank you.
Thank you.
Thank you. We have e-court and online dispute resolution. At the Law Council of Australia, just to finish off for you, we are looking at commentaries and extensions of our guidelines to include online dispute resolution and Med-Arb and other hybrids. So just something I also wanted to highlight to you in the last few seconds is Article 5.1 of the Singapore Convention on Mediation. It brings in the activity of the mediator and the standards in which a mediator must adhere to. And if the mediator fails to do so, there is also an impact upon the enforcement or how that particular agreement, which is reached at the conclusion of a mediation, might be dealt with. So that's all I really wanted to raise with you, and I thank you for the opportunity.
Thank you so much, Mary. I apologize, of course, that I have to interrupt very interesting speeches. I apologize to Anna, for instance, because it was really interesting to see the evolution and the reflection that she proposed with the AIJA. I will not make a summary because it is very rich, but I point out the digitalization. It was in the speech of Anna, but also in the speech of Shyam. It is, I think, a good way for our reflection is to go ahead in the digitalization to win time and, of course, to give a better service to the population in all the matters covered by the ADR. Also, the need of a a flexibility. I have seen that in the speech of Panagiotis, of Remigijus, of Mary. You speak about guide, about soft law, about guidelines. So I think the rules must have as much as possible flexibility. And perhaps the last point that I want to underline is that it must be efficient, of course. And the efficiency is, of course, the time the time limit. I see that in the speech of Shyam, the time limit of 10 months for arbitration. Otherwise, they go to the court. I think that's a very good point. And also the enforcement of the sentences. Of course, we don't speak about sentences, but of the settlements, sentences if it's an arbitration. And I have heard with pleasure the welcome of the Indian state to the enforcement of international arbitration sentences. And I think everybody has understood that those reflections are only the beginning of something, and that I think we have to come back next year or in 2 or 3 years. Thank you so much. And I give now the floor to Madam President and to Rafal. And I hope that you will accept some minutes that we have taken on your coffee.